Good afternoon and welcome to those of you that have joined so far. We have just opened the link, so we're just waiting for a few minutes to allow everybody to join before we start. Good afternoon and welcome to those of you that have joined. We have just opened the link, so we're just waiting for a few minutes to allow everybody to join before we start. Good afternoon, everybody, and welcome to the Five Stone Buildings webinar program. I'm going to hand over to our speakers now. I'll hand over to Amanda.
Many thanks, Jo, and welcome to everyone. Good morning or good afternoon now, and welcome to this webinar. I'm Amanda Hardy, and we also have Oliver Marr, who will wave, and Sam Chandler, who will also wave, just so as you know who everybody is. And we're presenting today the Five Stone Buildings webinar on judicial review remedies in tax disputes, if I can get my words out. And we're all going to have a significant input today, but I want to start with an introduction and really just to note that there's been a significant rise in judicial review applications against HMRC, as I'm sure you're all aware. I think I was involved in one of the first judicial reviews against the revenue. Certainly, I think it was the first successful judicial review over 20 years ago, which was the Unilever case. And at that point, a judicial review was a rare occurrence. That involved practice of the revenue that had grown up in relation to allowing late submission of figures. And there was then a change in inspector. And the new inspector wouldn't allow the practice to continue. And the Court of Appeal decided that there was a legitimate expectation to at least have notice that the treatment was going to change. And so that was that was a rare occurrence, as I say, of a successful judicial review being brought against the revenue. But that we find them in many arenas in tax disputes now, and we'll come on to describe some of those. But by way of introduction, as we've put on the slides, there are some advantages now to judicial review applications. They can be quick and efficient, a quicker and efficient method of overturning the revenue's decisions, and that includes quashing decisions that are made by revenue officers, or even forcing the withdrawal of assessments that have been issued if it's strategically placed. And they can also be used as a wider strategy in dispute resolution and settlement negotiations, because if you have a tax dispute on substantive law, it may just be that strategically issuing judicial review proceedings may be taken into account in the overall settlement with the revenue. But as we say on the slides, we do need to have a very robust claim with a good chance of success, because the work that you have to do when you establish a judicial review has to be front loaded. We have various protocols that we have to take into consideration. Grounds have to be drafted really very carefully. And also the parameters of what's required to successfully win a judicial review case has fluctuated in recent cases. So it also requires a clear understanding of the procedural issues and evidential rules of the High Court, which obviously are different to the first tier tax tribunal, and a very close eye on time limits, because these are very strictly enforced in judicial review proceedings, and we'll come on to those again in a moment. So when is judicial review relevant? And again, as I'm sure you're all aware, for most tax matters, there are specific appeal procedures that are set out in the statutes. And if there is a suitable appeal process, then it's not suitable or indeed permissible to bring judicial review proceedings instead. But in some cases, there's no right of appeal to the tribunal against an HMRC action, and they're the ones that are suitable for judicial review. And as we say, this is mainly when the decision made is in relation to a discretionary matter. For example, a decision on whether a late claim should be accepted, or the application of extra statutory concessions, or more recently in relation to HMRC guidance and the application of the guidance by HMRC themselves. In addition, there are some areas of law where there is not an appeal from the FTT possible, for example, in relation to DOTAS applications. So then if you want to challenge the decision that's been made, you have to bring judicial review proceedings in those cases. And for example, other circumstances where, for example, the tribunal itself has refused, for example, a late appeal, there's no appeal onwards. And if you want to challenge the decision that the tribunal has made in those circumstances, you have to bring judicial review proceedings. So there are a number of circumstances that are suitable for judicial review, but generally the rule of thumb is if you've got an appeal procedure to the first tier tribunal, that's the process that you should be undertaking. On to Oliver.
As the slide says, that there are other specific circumstances where JR might be appropriate. For example, if the revenue publishes guidance and you as a taxpayer rely upon it, or if you go to the revenue and seek clearance, or you have an exchange of correspondence which amounts to an assurance that they'll allow you to continue to arrange your tax affairs in the way that you have hitherto been arranging them, and they later resile from it, then you might have good grounds to challenge the revenue's later assessment if it conflicts with that agreed treatment or that promised treatment. So that would tend to be where there's not a dispute about whether or not your tax returns or the revenue's assessment is technically correct, but where you claim that you were misdirected and in consequence suffer a disadvantage. And the other point on that slide is a slightly different one, which is that where you have a right to bring a challenge in the tax tribunal, a statutory right of approval, then you can't bring JR on the same matters. So you have to scope out where your claim lies. And this is something that Sam's going to delve into in more detail in a moment. Sometimes there'll be a limited right of appeal to the tax tribunal, but there'll be various grounds which are relevant to your claim which fall outside the limited right of appeal. So for example, does everyone remember follower notices? Those are notices that the revenue has a wide discretion to issue if they form the rational view that your tax case would be, the reasoning given and law applied in a decision, a final decision in another taxpayer's tax case would automatically apply to your circumstances. Now they can issue that and there's no right of appeal against a follower notice. So you can't go to the tax tribunal and say, I don't think the revenue should have issued this follower notice because I don't think I would be bound by the decision in that other taxpayer's case. What you can take to the tax tribunal is a penalty appeal. So if you get a follower notice, you don't obey it, you don't concede and pay the tax based on the decision in the other person's case, then the revenue can issue a penalty. And in follower notice penalties, the amount of the penalty is very high. It's an automatic 50% of the tax said to be due. And you can appeal those penalties to the first tier tribunal on limited scoped grounds that appear in Finance Act 2014. If you want to challenge the underlying notice or you want to challenge the penalties beyond those limited grounds, you'd have to bring a separate action in judicial review. And there's an example of that there. PML accounting sees that sort of process in action. As I said, Sam's going to talk in more detail about forum, when you should be using the first tier tribunal or the other tax tribunals, and when you should be thinking about the High Court and judicial review. But just before I hand over, I wanted to make a sort of overarching point, which is that both JR and tax tribunal proceedings have strict time limits. And you want to make sure that while you're doing your forum analysis, you don't miss the opportunity to bring the right bit of your claim in the right forum. You don't want to end up like that chap in the straw hat who's missed the boat. And so to help navigate those choppy waters, which are probably slightly choppier than his summer holiday waters, I'm going to hand over to Sam.
Thank you, Oliver. So I want to spend a bit of time looking specifically at this issue of forum. There's been a striking number of recent cases addressing this issue, all of which serve to reiterate that the question of where to bring proceedings is not always clear-cut. And as Oliver has noted, bearing in mind the fact the consequences of getting it wrong can be pretty grave, it should be on all of our radars as practitioners. Now, this is a pretty large subject in its own right, with a number of interesting cases to consider. So I'm going to canter through just a select few of them in order to give a flavour of some of the issues that arise, and before concluding with a few practical points for practitioners to consider. Before I do so, however, I want to outline three preliminary underlying points of particular relevance to this question of forum. And the first, which you can see there on the slide, is that the FTT, being a creature of statute, has jurisdiction only to hear claims which are strictly set out in statute. So generally speaking, it is not empowered to hear public law claims. And you can see there on the slide the fairly unequivocal extract from the decision of the upper tribunal in the case of Knorr. That does not mean, however, that the FTT cannot, in some situations, resolve public law questions. And we'll take a closer look at that in a moment. The second point, which is on the next slide, is that the UT does have a statutory jurisdiction to deal with JR claims, but it's extremely limited. So it has jurisdiction to review certain decisions of the FTT against which there is no further right of appeal, specifically certain excluded decisions within the meaning of Section 11 of the 2007 Act. And very broadly speaking, these concern non-appealable decisions on the part of the FTT to review or to set aside earlier decisions of the FTT. In addition, and this is important for reasons which we'll go on to address, the UT also has jurisdiction where proceedings are transferred to it by the High Court because it is just and convenient to do so. The third and final underlying point concerns the exclusivity principle. Now that's the principle first established by the House of Lords in the case of Macman and O'Reilly, that generally speaking, it's an abusive process to seek to vindicate public law rights in private law proceedings. And as you can see there from the case of Trim, which affirms the principle in a 21st century context, it prevents litigants from circumventing the special procedural rules, or what Lord Justice Carnwath calls there the streamlined procedure, which is specific to JR proceedings. As ever, there are exceptions to the exclusivity principle, including notably where the invalidity of a decision on the part of a public body is raised as a defence to enforcement proceedings. And so that's the Winder exception, which derives from the case of Wandsworth and Winder, which you can see there on the slide. So with those three preliminary points made, I'm going to turn to the first of the three cases I'd like to consider, and the first of which is Nibs in the Court of Appeal. Now, by way of context setting, and as many of you will be aware, tax schemes often have used LLPs claiming transparency status on the basis that they're trading with a view to profit, and the members then use LLP losses to claim loss relief. Now, where the revenue has challenged the scheme at LLP level, for example, by amending the LLP return, they will usually serve notices under Section 28B(4) of the Taxes Management Act on the individual members, making consequential amendments to their returns. The case of Nibs concerned a number of participants in various schemes who had been served with notices under Section 28B(4), denying their claims for carryback loss relief. And their response was to bring Part 7 proceedings in the High Court, challenging the validity of those notices by way of declarations on the basis that the revenue had failed to bring requisite inquiries. And the revenue applied to strike out the claims on the basis that they ought to have been brought by way of JR, and they obtained judgment in their favour in the High Court. And the matter ended up in the Court of Appeal, which handed down its decision in October of 2019. And essentially, the Court of Appeal agreed with the High Court that there was no statutory right of appeal in respect of a consequential notice issued under Section 28B(4), such that it was a matter of pure public law, and the right way to challenge such a notice was therefore by way of judicial review. And bringing the claims by way of Part 7 proceedings was an abusive process. So yes, it upholds the decision of the High Court to strike out the claims on the basis of the exclusivity principle. I should say that I've argued a similar, though preemptive claim for the revenue, in which the taxpayer, realising that the revenue was about to issue him with a Section 28B(4) notice, brought proceedings for a preemptive declaration that it had no power to do so. And the court had no hesitation in striking out the claim on the basis of Nibs. You'll see there, I've just flagged the decision of the upper tribunal in the case of Reed and Emblin, in which Mr. Justice Newgee held that Section 28B(4) notices were not closure notices and could not be appealed to the FTT under Section 31 of the TMA. He held that such claims would have to be brought for judicial review. So that's Nibs, where the nature of the revenue's decision, a notice from which there was no statutory right of appeal, dictated the correct forum. I want to deal with a slightly different type of case where the forum is driven by the nature of the challenge. And in such an instance, it appears that the primary question is whether the challenge falls within the scope of the FTT's statutory jurisdiction. The facts of Burkitt, which you can see there on the slide, can be set out pretty shortly. Mr. and Mrs. Burkitt failed to comply with an information notice issued on them under Schedule 36 of the Finance Act 2008. Penalties were imposed, and they appealed to the FTT against the penalties pursuant to the specific statutory right of appeal conferred by paragraph 47 of the schedule. In the course of that challenge, Mr. and Mrs. Burkitt advanced a legitimate expectation argument, and the FTT found that it didn't have jurisdiction to deal with this challenge, and they appealed in this regard to the upper tribunal. Now, the UT noted that whilst the FTT did not have a JR jurisdiction, and that did not mean that it never had any jurisdiction to consider public law questions, and it held, and this is the key point to draw from the decision, it's on the next slide, that it was necessary to consider the specific jurisdiction being exercised by the FTT, and whether the point that was raised is one that falls to the FTT to consider in exercising that jurisdiction. So you'll see the extract from that over on the next slide. So it's a question of statutory interpretation, which means that it may not be clear cut. With those observations in mind, the third and final case I want to consider is the recent decision of the Court of Appeal in Beadle. Now, by way of context setting, there is no statutory right of appeal in respect of a partner payment notice. However, where the revenue has issued a penalty for late payment, there is a right of appeal to the FTT in respect of that penalty on the grounds of reasonable excuse. Now, in this instance, Mr. Beadle had been landed with a penalty for non-payment, and he brought an appeal to the FTT on the grounds of reasonable excuse, but he also argued that the underlying PPN was a nullity in law. And the FTT found that there was no jurisdiction to determine the validity of the PPN in the context of such an appeal. The UT agreed with the FTT, and the matter ended up in the Court of Appeal. And the Court of Appeal decided, and you'll see on the next slide there, it decided that in the light of the purpose of the statutory scheme for PPNs, taxpayers were by clear and necessary implication precluded from raising public law challenges against the underlying validity of a PPN in the context of an appeal to a penalty. It held that enabling taxpayers to challenge penalties by raising the invalidity of a PPN would amount to a statutory appeal by the back door in circumstances where Parliament had expressly provided expressly not provided any right of appeal against such a notice. So on that basis, it found that the winder exception to Macman and O'Reilly didn't apply. You'll see there, I flagged the case of Archer. This is a decision of the Court of Appeal in which the taxpayer correctly brought a claim in JR against the validity of an APN, but it did so before statutory representations had been made to HMRC. And the Court of Appeal found, actually in the context of a dispute about costs, that the JR proceedings were premature, and that the HMRC review procedure ought to have been exhausted and before those proceedings were issued. That is the case of Beadle. I note that I've dealt with examples of where the courts concluded that taxpayers' challenges ought to have been brought by way of JR rather than FTT proceedings. It is not always that way around, of course. And you'll see there, in the previous slide, I've flagged the case of Archer, and where the revenue contended successfully that the challenge to a closure notice ought to have been brought in the FTT rather than by way of JR. And Oliver's mentioned the case of Glencore already. So some concluding remarks. We've looked at a handful of cases, and on the slide there you can see some headline points. A couple of practical points to bear in mind. With an ever-growing body of authority behind them, the revenue is taking a fairly active stance in running procedural points in proceedings where it considers that proceedings have been brought in the wrong forum. So the obvious point is that careful thought ought to be given to the issue of forum before proceedings are issued, and it needs to be done timelessly, as Oliver has noted. If you take the wrong course, then you may miss the relevant time limits and be left without a remedy. Sometimes your dispute with the revenue will straddle both the High Court and the FTT, and in that instance you may wish to issue in both. So for example, I've flagged the decision of Cobalt, where the taxpayer's challenge to revenue determinations in the context of capital allowances also involved a legitimate expectation argument. So the LLPs issued in the FTT and the High Court, and the proceedings were transferred to the UT as the first instance tribunal. I can now hand over to Amanda and Oliver, who are going to discuss the question of procedure.
Everyone's heart soars when you get to the procedural bit of a talk, especially a talk on tax law. There's a bingo of boring. So we'll try and make it as quick and painless and hopefully even a little bit interesting as possible. As Sam said, this process, which we saw in action in Cobalt, whereby you can have your judicial review in the upper tribunal, and so you can have the substantive tax technical arguments at the same time, is the right way forward. But that requires a sort of strategic analysis. You want to think about the respective strengths of your cases, and you want to think also about what the result of winning one or other of the winning in one or other of the fora is going to be. So it won't always be the right decision. And in fact, at the moment, Amanda and I have a number of judicial review applications which have been stayed by the High Court prior to any consideration of whether they should be held in the administrative division or whether they should be heard eventually in the upper tribunal, pending first tier tribunal appeal proceedings. So we're dealing with the tax technical dispute first in the tax tribunals, according to that statutory jurisdiction that they have, of which Sam was speaking earlier, and dependent on the result of those. So basically, if we don't win, we then have these proceedings which have been lodged within the appropriate time limits in the High Court, which can then be picked up. And that's a way of trying to save cost apart from anything else, because it means although you've done a certain amount of this front-loaded work that Amanda mentioned to get the JRs up and running in good time, you don't have to have the full hearing of the JR until you determine that it's actually necessary. And it says there on the slide, often HMRC would agree to stay one or other of the proceedings. I have to say, in my experience, and certainly in these cases that Amanda and I are doing together at the moment, the revenue have been entirely amenable to that. It's an area where taxpayers, litigation teams and the revenues litigation teams can work very collaboratively to work out the best way forward. So that is a sort of procedural stroke strategic analysis that you want to be carrying out to decide what best suits your particular dispute. Let's assume, though, that you are going to bring JR, that you do have something that can't be dealt with in the tax tribunal. What do you have to do first? Well, before you start your action, you need to look at the pre-action protocol, which Amanda mentioned. And the most important substantive step under the pre-action protocol is to make sure you send a pre-action letter. And the point of pre-action letters in judicial review proceedings, as really in all litigation, is to try and narrow the issues between the parties so that your hearings, when they come along, or your pleadings, when you get round to drafting them, can be as directional and sensible as possible. In JR, because of the fact that when you're bringing your judicial review application, you need to lodge all your evidence on day one, your pre-action letter also gives you a very nice opportunity to ask the other side, in the majority of cases that we're talking about, the revenue or the public body in general, for the evidence that you think that they might have, but which you do not have, on which you want to rely. So there's a fact-finding and evidence-finding limb to the pre-action letter. And because the response from the public body, or in most cases the revenue, is therefore going to be substantive and important, you need to make sure that you give them sufficient time to come back to you with a reply which will hopefully be helpful before you have to lodge. So if you've got your 3-month at the most time limit to bring your JR from the date of the decision, you've got to factor in the process of exchange of pre-action correspondence in that way. You don't always have to give the revenue 14 days. You may not simply not have 14 days. And the law reports are littered with examples of occasions on which taxpayers have had to bring protective judicial review proceedings very quickly indeed, especially if they're going to be stayed, but that's the ideal. You then have to apply for permission. And that really means that everything for the JR has to go in, because the permission decision is usually based on a fairly comprehensive analysis of the strength of the case that you're bringing. And that application, whether or not your JR is eventually going to be heard by the upper tribunal, the permission application first has to be lodged with the High Court. And there is the time limit. You see at the bottom of the screen, there's a graphic reminder that it's 3 months. And in the first bullet point, the words promptly and in any event within 3 months appear. And Amanda is going to unpick those for us in a moment. And at that stage, the High Court will decide on the application for permission. Now, it may be that the High Court says it needs a hearing to determine permission before and distinctly from a hearing to determine the substantive application. It may be that it declines permission on the papers, and this does happen from time to time because permission applications on the papers can sometimes be dealt with relatively quickly by busy judges who are more interested in stopping people from being extradited to terrorist sites and so on. And so you sometimes then have to apply for an oral reconsideration of a denial of permission, and that's not unusual. And it's an automatic right you have to request a hearing if your application for permission is first turned down on the papers. But hopefully it's plain sailing and you get permission on the papers, and the first time you have to turn up to court is for the application itself.
And coming back again to timing issues, and Oliver's set out the requirement that judicial review proceedings have to be brought promptly, even when it's been brought within 3 months. And as Oliver's indicated, there's been a number of cases where HMRC have challenged whether or not proceedings have been issued promptly enough, even if they have been brought within the 3-month period. And as Oliver explained in relation to the pre-action protocol system, it's not really quite 3 months you've got, because you have to get your pre-action letter to the revenue in good time to enable them to think about it and have at least ideally 14 days to respond. One interesting, I think, fact that Oliver and I have seen in the last few months, we've had 2 judicial reviews that have needed to launch within the last 3 months to be within the 3-month period. And we have, as with all judicial reviews, taken the view that it's much better to be safe than sorry and get it in before the 3-month period. And we did in both cases. What is interesting is the revenue have reserved their position in relation to promptness, even in these COVID-related circumstances. So where taxpayers have had, obviously, along with all of us, a very different sort of form of working and period of time over the last few months. Interestingly, HMRC have even in these circumstances reserved their position in relation to promptness, which I do find a little surprising, because I think on the other hand, I think one of the webinars that we've done before, and some of you will have attended, in other areas the revenue have been really very helpful in relation to COVID-related delays and COVID-related issues. So it's quite interesting that in judicial review proceedings they're sticking very much to their promptly time limits. It doesn't, as we say on the second bullet point, except in exceptional circumstances. It doesn't override a requirement to comply with the procedural protocol, the pre-action letter process. And in Archer, which Sam's already mentioned, there was actually another case that went all the way up to the Court of Appeal. The Archer case went to the Court of Appeal twice, and the second case was a costs case. And the Court of Appeal said that that was a subject that would not normally justify a first outing to the Court of Appeal, let alone a second appeal. But in that case, Mr. and Mrs. Archer were issued with some of the first APNs, the accelerated payments notices that are linked to DOTAS-related arrangements. And what's of interest in this case is the decision and the judgment of Lord Justice Henderson in relation to the costs application brought by Mrs. Archer after her APN had been withdrawn. So there was not an APN on foot. And she then brought a costs application to try and get back the costs that she had expended in issuing the judicial review procedure. And there was quite a lot in front of the first judge who looked at it, who was the master, and then in the High Court in relation to whether or not it was premature for her to bring those proceedings, which is an interesting and important question to consider. It's quite difficult if you've got to bring something promptly and within 3 months to be sure that you don't also bring it prematurely, because you can be caught between two stools there. And one of the Revenue's arguments here was that the proceedings had been brought prematurely rather than too late. But the interesting comments I think of Lord Justice Henderson are in relation to the pre-action protocol point. I mean, he was looking at the review period of 3 months, which you have under the APN and follower notice procedures, and he referred to that as a generous 3-month period to put in representations, a similar period to the judicial review. And actually, it's quite interesting because 3 months practically can, in cases, often not be generous from the perspective of a taxpayer in a complex action where you're having to get quite a lot of evidence together to substantiate a claim that must stand up on all of its grounds, and which must, as we'll discuss shortly, reach a very high bar to persuade the court to give you permission. And particularly, I think, in the last few months where people have been grappling with not being actually in offices and not being able to sign witness statements and things like that, 3 months can actually trickle by quite quickly. What Henderson had to say as well, I thought was interesting in relation to the actual pre-action letter. One of the pleaded grounds of HMRC's defence was that in this case, the clients had not put in a pre-action protocol letter at all. That there was some dispute as to whether or not a letter that had been issued by the client's accountants could satisfy that. But in effect, it wasn't a pre-action protocol letter that complied with all the requirements of the protocol. So I think the better view was they hadn't put that in. And I think that weighed quite heavily on the Court of Appeal when they decided that the master couldn't be criticised for not awarding any of the costs of the failed judicial review proceedings on the revenue. So I think it's really important to make sure that you comply with the pre-action protocol, and all the indications are that the revenue are going to be arguing that they should be brought promptly but not prematurely, and that's a careful sort of balancing act. And as I say on the last slide, consideration will need to be given in any case to the question of what is the decision which is being challenged, and that really feeds into this question of whether it's premature or not, as to whether or not, for example, in the follower notice type scenario, you should be challenging the initial follower notice that's issued to you by way of judicial review, or whether you should wait until you've got the representations and you've put those in and they've been looked at by the revenue. In the early days, there was, I think, some real concern that if you didn't challenge the follower notice itself, then the revenue might argue that you weren't within your 3-month time limit. But if you waited until you got your response to the representations, then you were out of time. In fact, I think that's the other way around, that you were premature if you went against the follower notice itself, but you were then out of time if you waited to the response. But I think that has been thankfully cleared up now. So on to procedure, grounds, evidence and costs, the next slide. The party who's applied for permission can only rely on the grounds given in their application unless you go back to the High Court or the Upper Tribunal to ask them to give permission to include other grounds. So I think the lesson there is that the grounds are really important and require very careful drafting, because it's much worse to have to go back and expend further time and costs asking for expanded grounds to be given permission. Both the party applying for permission and the party opposing it can provide evidence and make representations at any hearing. So one would expect the revenue to put in their own evidence, particularly in relation to document finding, etc. And they will, of course, make representations. The court and the Upper Tribunal can award costs in judicial review proceedings. That's just something to remember, because, of course, the First Tier Tribunal has its own cost regime, which you can opt into or opt out of. But it's the standard costs jurisdiction that you need to look to for judicial review proceedings. So pleading the grounds, I said that's very important. Generally, the court quashes decisions where there's been unfairness amounting to an abuse of power, and you'll see why we say this is a high bar. The courts will not interfere in a decision merely because it's harsh and it appears unfair. You have to have a much greater degree of unfairness. Quite what that is still an open question. I'm coming back to Healy Hutchinson a little bit later, but we've had some recent case law, vacation rentals, which Oliver's going to look at in detail, which is a decision of Mr. Justice Fancourt, where he said once you had your legitimate expectation established, it's then for HMRC to identify the overriding interest that frustrates that expectation once established. And that seems to us to be a very sensible way of approaching the bar that needs to be vaulted in order to get a judicial review proceedings off the ground. And Oliver's going to come back to Meehan as well, which had something to say about vacation rentals. It's clearly for the taxpayer to prove that they've got a legitimate expectation and what flows from that. And there's some question as to whether the recent Court of Appeal decision in Azora has really raised the bar even higher than has been expected in the past. But Oliver's going to come back to that in a second.
So as Amanda says, one of the specific grounds for judicial review that will very often be relevant in the context of bringing an application for review against the revenue will be legitimate expectation. That is where the revenue has made a statement, either in a statement of practice, for example, in the manuals, or by giving clearance to a taxpayer on the basis of a clearance application, or in general correspondence, and later does something which frustrates the expectation that they've created, that a specific tax treatment will be applied. And in MFK underwriting, as long ago as 1989, it was accepted that it could be an unfair abuse of power for the revenue to depart from their guidance or from informal clearances given to individual taxpayers. And this has become an especially hot topic in the current legislative climate, because back in 1989, the context was that taxpayers had sought clearance for specific transactions from the revenue. What happens an awful lot at the moment, especially in legislating anti-avoidance legislation, is that the terms of the anti-avoidance legislation will be extremely wide. If you think about something like the transfer of assets abroad provisions or the profit fragmentation rules that came in last year. The terms of the statute are very wide, and what subsequently happens is that the revenue clarifies or narrows the scope of application by issuing guidance to taxpayers. And the question then arises, well, what happens if the taxpayer does something which falls, say, not to be taxed on the basis of what the guidance says, but may if you look at the wide wording of the underlying statute, appear at least at significant risk to come within the words of the statute, and then later the revenue come knocking and say, well, it falls within the terms of the statute, so please pay up. Can the taxpayer rely on the guidance or not? And that's the current scenario that's producing an awful lot of these public law disputes between taxpayers and the revenue. Now, MFK, which still contains the underlying authority on what you need to have produced, therefore needs to be interpreted in that context. And the first requirement set out by the court in MFK is the taxpayer has to put all his cards face upwards on the table. And now, in the context of applying for statutory clearance or non-statutory clearance, that would require providing full details of the specific transaction. And that's long been swallowed up into kind of good practice or essential practice for taxpayers and their advisors generally. If you're applying to the revenue for clearance, you obviously have to tell them everything there is about your transaction. Otherwise, the clearance isn't worth the paper it's written on. And in fact, I think most clearance responses from the revenue now have a paragraph to that effect. So that's an important point. But more important in this concept of general guidance published to the whole world is that the ruling or statement from the revenue relied upon must be clear, unambiguous, and devoid of relevant qualification. And a lot of the disputes that we're seeing will basically come down to what is a relevant qualification? Can the revenue publish guidance and then say it's qualified so that it doesn't apply, or when they publish guidance, is the prima facie position that you should be able to rely on it as a taxpayer, and that the carve-outs from that permitted reliance have to be fairly precise. An example of where one saw this in action was Gaines Cooper. It's a little bit old now, but it went all the way up to the Supreme Court, and so it's worth remembering. The statement of principle there in italics, the importance of the extent to which thousands of taxpayers may rely upon guidance of great significance as to how they manage their lives cannot be doubted. So your starting point is that the guidance matters. There's no point in publishing the guidance if it's going to basically be resolved from in suitable cases. There's a tension there identified quite nicely and subtly by Lord Wilson, where you have an obligation to collect tax on the one hand and guidance which might relieve the revenue of its obligation in certain circumstances on the other. And that's something that we're going to look at in a moment. But you need fair dealing and frank and open dealing on both sides of the coin. Now, when it came down to it, IR20, which was the guidance in question in Gaines Cooper, was held not to be clear and not to be unambiguous, which criticisms one might think are actually completely fair enough and largely the reason behind the statutory residence test, which we now have. But the principle and the decision in Gaines Cooper go slightly different directions, and it's worth remembering that the principle survives even though the taxpayers weren't successful on the terms of IR20.
And so coming back to another of the limits, as I mentioned, I was going to talk a little bit more about Healy-Hutchinson. And that turned again on the circumstances when HMRC guidance can be relied on. And in this case, the HMRC had issued guidance in 2003 on which the taxpayer clearly relied. But then in 2009, and reversing its position, issued guidance that was gave the opposite result to the 2003 guidance. And then HMRC refused the taxpayer's claim by applying the later 2009 guidance. The taxpayer succeeded in the High Court, but then lost in the Court of Appeal, with Lady Justice Arden recognising that the taxpayer did have a legitimate expectation in 2003, on which it relied, but then considered whether it was legal to frustrate that legitimate expectation on which it had relied by holding that it's well established that it's open to a public body to challenge a policy if it has acted under a mistake. or to change a policy if it's acted under a mistake, the decision whether or not to do so is not reviewed for its compatibility in the public interest. The question is whether or not there's been sufficient unfairness to prevent correction of the mistake. It is clear from the authorities that the unfairness has to reach a very high level. And she said in particular the holding of Simon Brown, Lord Justice Simon Brown in Unilever, where he held it was not enough that the change of course by the public body was mere unfairness or conduct which was a bit rich. And then she went on to say it had to be outrageously or conspicuously unfair. Well, pausing there, this is quite an interesting raising of the bar. It seems to me by Lady Justice Arden. If you go back and have a look at the Simon Brown judgment in Unilever, the leading judgment was actually given by Sir Thomas Bingham, the Master of the Rolls at the time, and his judgment was agreed with by Lord Justice Hutchinson. And I don't think you can read into Lord Justice Simon Brown's words of mere unfairness or a bit rich, with all due respect to Lady Justice Arden, the very, very high test of outrageously or conspicuously unfair. But there you are, that was what the Court of Appeal said, and the other two judges agreed with Lady Justice Arden. But it does lead, as we've hopefully illustrated graphically on our next slide, to a very high bar. It's worth remembering, but in Healy-Hutchinson's case there, the guidance was wrong. And that's what Lady Justice Arden was grappling with. You know, are the revenue allowed to change their mind if they've got the law wrong? And one can see the sense in being able to give the revenue the ability to correct its mistakes. But what about where the guidance is correct? Obviously, Oliver's mentioned IR20 and the Gaines-Cooper case and the recognition by Moses, who actually was counsel for the revenue in Unilever when he was in the Court of Appeal. He recognised that there had to be a judicial review claim that could be brought against statements made by the revenue that were clear and unambiguous. But what about cases where the revenue haven't got it wrong, where the guidance is correct and the guidance is clear and unambiguous? Well, watch this space. Oliver's mentioned a couple of cases that he and I have together, and we've certainly got some litigation coming where we argue that the guidance was correct, that the revenue haven't resolved from it. It is clear and unambiguous, and in fact, it's still in place a number of years later. So it'll be interesting to see where the bar falls in relation to those sort of cases. Back to Oliver.
And there's a movement in this direction that you can see in the judgment of Mr. Justice Fancourt, which Amanda trailed, vacation rentals. And it's worth just dwelling in the few moments we've got on that paragraph 90. If you can establish a legitimate expectation, that is, if you can show that the revenue has published something that legitimately gave rise to the course of treatment that followed, he goes on to say it's for the authority, that is for the revenue, to identify an overriding interest, which it relies on to justify the frustration of that expectation. And if there's no authority, if there's no material put before the court by the revenue to justify the frustration of that expectation, then the court can conclude that there's no sufficient public interest and the legitimate expectation is prima facie unfair to frustrate. We mentioned briefly earlier the case of Meehan, which was a decision just published last week. And it does that thing which judges have to do sometimes, of weaving a careful path between two authorities which apparently conflict on their face, by digging behind them and looking quite carefully at the facts. And it's very helpful in that regard to see its starting point is vacation rentals. So the upper tribunal in Meehan says the starting point is that once you have a legitimate expectation created by a clear and unambiguous publication from the revenue, they are prima facie bound by it. And now it does have to be unfair for them to depart from it. If it's not unfair in any way, shape or means, of course, you probably wouldn't want to bring a judicial review. If it's only a little bit unfair, because it means you have to pay tax in accordance with the law because the guidance is wrong, say, then that's not going to help you persuade a High Court judge to say that you actually don't have to pay the tax. But it's a sliding scale, and what you're doing is you're building blocks of unfairness according to your specific facts. And the next slide illustrates one of those building blocks, unequal treatment. Often a client will say, such and such treatment by the revenue mustn't be right. It must be unlawful and therefore open to reversal by the court, simply because my friend, Mr. Bloggs, was not treated in the same way. And that's not right. That's not independently a ground to have a decision of the revenue, if it's otherwise right, struck down just because they were kind or wrong in someone else's case. But what it can do is be a very important and fundamental building block to showing unfairness when you need to. So looking around for evidence of how other taxpayers in similar positions or broadly analogous positions were treated can be a very useful piece of research when you're looking at the strength of your judicial review claim. And the second bullet point there says it's also relevant to Human Rights Act arguments. Of course, if the way in which you've been treated unequally is a way which breaches one of your human rights under the Act, that can be a completely separate line of attack, also likely to be by way of judicial review, likely to be pleaded concurrently with your unfairness point. But that's not what was happening in Gallagher. That first bullet point there, what was happening in Gallagher was just showing the unfairness by unequal treatment. And so that's quite an important thing to bear in mind when you're looking at these claims.
And finally, just onto another sort of area of recent judicial review cases. I've already mentioned briefly follower notices and accelerated payment notices. And there have been a number of relatively recent high profile public law challenges that have concerned APNs. And we've listed them here. And these were all victories for HMRC once they'd finished their movement through the courts. But on to follower notice cases on the next slide. There's been more taxpayer success in relation to those. And there's a case at the moment called Hayworth. And in that case, the Court of Appeal did allow a judicial review against a follower notice in that circumstance based on the Smallwood decision and quashed the follower notices, saying that the HMRC had misdirected themselves, firstly by misunderstanding the Smallwood judgment, which was based on an Edwards and Bairstow analysis of facts in that case in front of the special commissioners, and therefore couldn't be directly determinative of a taxpayer's case with different facts. And also, as the revenue had worked on the basis that the follower notice could be issued if HMRC themselves were merely of the opinion that it was more likely than not that the principles or reasoning in Smallwood would deny the asserted advantage. That wasn't the basis on which the revenue should have worked. So they were therefore incorrect to believe that these two cases, Hayworth and the Smallwood case, were identical, and they involved questions of places of effective management, and they were different on the facts, and each case is fact specific. Therefore, the Court of Appeal said that Smallwood couldn't be used as a basis for issuing follower notices and APNs, and that is on its way to the Supreme Court. But now there's been, I think, eight judges altogether in that case have held that that's the right construction. In Locke in 2019, again, the Court of Appeal decided for the taxpayer. There were follower notices and APNs issued to a participant from a film finance partnership in that case. And again, they said that HMRC were wrong to decide that the Eclipse judicial ruling would be relevant to the facts of this rather different case. So in APNs, I think the taxpayer hasn't had really very many successes, some small dicta to help various cases. But in relation to follower notices, there has been some more substantive decisions in favour of the taxpayer. And so finally, I just want to highlight and mention a recent case a week or so ago, JJ Management Consultants, and this dealt with extra statutory information requests, which had been made by the Revenue, which was backed by a threat of non-mitigation of penalties. And perhaps somewhat surprisingly, the Court of Appeal upheld the upper tribunal's decision that HMRC are entitled to conduct informal investigations into taxpayers' affairs, which are entirely outside the normal statutory time limits. They then went on to accept that, of course, these sort of requests that were outside the normal statutory time limits because inquiries hadn't been raised in time, for example, could, of course, be subject to a judicial review. But they noted that a case would be wholly exceptional to be able to challenge such a request by way of judicial review. And so the knock-on effect for cases where you have a Schedule 36 notice, which itself is usually appealed to the first-tier tribunal, one of course has to look at the specifics, is really rather interesting if we're now in a position where the Revenue can issue information requests outside of the Schedule 36 notice periods and legislation. So that's quite an interesting decision that we wanted to finish on. Well, I think we are at 1:02. So many thanks to everyone for listening, and we look forward to seeing you all at further webinars shortly.